Hearing the appeal of the Kingdom of Spain and another against the London Steamship Passengers Mutual Insurance Association.
Mr. Delamere.
My Lords, as you know, I appear with Mr. Hancock, Miss Tan and Mr. Thompson, the appellant, the club. States are represented by Ms. Delnott and Ms. Hart. I'm addressing you on ground one. And ground one, contrary to the slightly misleading summary of the proceedings, which gave me flashbacks to arguments at an earlier stage in this case. Ground one is all about whether a party fixed with an equitable obligation to arbitrate, arising from the application of the conditional benefit principle, can ever be sued for equitable compensation or indemnification for either the past losses or the future losses that flow from its past or anticipated breaches of that obligation to arbitrate. Now, on the most abstract level, this case raises some pretty fundamental questions about the nature, role, and availability of equitable remedies and their relationship to equitable obligations, and then as to how those general principles feed into a case where equity imposes an obligation via conditional benefit reasoning. But it's necessary, I'm afraid, to start with a word of warning as to the things as to which there's no room for argument about in this case. There is no room for argument about the existence and the extent of the state's equitable obligation to arbitrate. There's no room to argue about their repeated, calculated breaches of that obligation, an obligation well known to them from the proceedings in which they had actively submitted and participated, and whose declarations they then flouted by obtaining the Spanish judgment, which they threatened to enforce abroad. And there's no room for argument about the jurisdiction of the two arbitrators who granted the relief about which we're here now arguing. And lastly, there is no room for any argument about the content of the equitable obligation to arbitrate. That equitable obligation is a full replica of the contractual obligation of the insured into whose shoes the states have stepped. All that remains is questions of remedy, and all that is permissible are those arguments about remedy that can be advanced consistently with the issue estoppels flowing from the very many arguments that have been run and lost by the states along the way in this very lengthy litigation. Now, I make these fairly obvious points because one of the hallmarks of the state's argument is a frequent attempt to recycle, in the guise of arguments directed at the availability of equitable compensation, is to recycle points that they've run and lost at earlier stages in this litigation. Points like consent, for instance, or like the supposedly distinct and special nature of direct actions compared to subrogation or assignment, or cases about causation or comity. All points that have been run by the state in the context of different arguments, run to finality, and as to which there is no appeal before this court. What then are the pure points of law about the court's power to award equitable compensation for breach? Now, given the limited authority that is truly on point, authority which is mostly confined, we would suggest, to the context of the conditional benefit applied in cases of mining and estates cases, Ground one does feel at times, I say this with particular feeling, a bit like an exam question that one of the panel might have been in the habit of setting in a former capacity. And our case, I would suggest, has a clear and simple answer in 3 stages. Stage 1 is that equitable compensation should be provided as a remedy when that is required effectively to protect or discharge the particular equitable obligation in play. It's the nature and purpose of the equity that rules the form of relief that will be made available in consequence of its breach. So says AIB and other cases. And there is, in our submission, no other rule or requirement, whether of consent, voluntary assumption of liability, or so forth. The second point we make is that the nature of the equitable obligation in play here is one that is arisen from and modelled upon and intended to give full effect to a contractual obligation. The contractual obligation is enforced at equity because it would be unconscionable to allow a party to take the benefit of an agreement without the indissociable burden. So, once a party acts sufficiently to amount to a clear choice to take the benefit, once, if you like, the equitable trigger is pulled, the contractual burden that is indissociable applies, and from that point onwards, the analysis is in substance purely contractual. So in AIB terms, the critical and distinctive feature of the conditional benefit principle is that it enforces a contractual promise against a third party. And that's because of the policy of equity in conditional benefits cases is clear and it's unbending. A stranger to a contract who wants to, is able to, and does choose to take such a benefit, originally promised to someone else, that is a stranger which itself wants to pierce privity of contract, can only do so if it's willing to accept at the same time the indissociable limits and indissociable obligations that are placed on the benefit they choose, and that includes, for present purposes, forum obligations. And our case is, thirdly, that once equity acts in this way to enforce the indissociable contractual promise, the remedies in equity for breach of the obligation should mirror those provided in contract. That here means the club should be no worse off in remedial terms when facing a claim by the states than it would be if the states were the original contracting party against whom at law they could obviously recover damages for breach of the duty to arbitrate, even if Section 13(2) of the State Immunity Act precludes the grant of an injunction. We say that three-step analysis is consistent with the general approach of equity, it's consistent with the nature and basis of the conditional benefit principle, and it's supported by authority. And that's because if the whole point of the conditional benefit reasoning, as Lord Hodge explained in Atlantic Confidence, is to avoid inconsistency of result or analysis compared to the original contract, or to put it another way, to avoid a weakening of the position of the party that is not seeking to benefit from the piercing of privity, then of course the club should be able to get a monetary remedy in equity akin to contractual damages on breach of the same obligation. And we ask rhetorically, how more incoherent or inconsistent could it be for equity to say that such an equitable obligation derived from and replicating a contractual obligation is treated as contractual for the purposes of the law of characterisation. That then leads to contract and the contractual choice being the governing law under the arbitration for the purposes of Section 46 of the Arbitration Act. It then leads to contractual principles of construction being applied to the document containing the obligation. It then led, as is apparent from Sir Peter Gross's award, to contractual rules on causation and mitigation of loss being applied to the analysis. And it leads to the contract for the purposes of anti-suit relief being treated as a contractual forum case, triggering the angelic grace principles. So at every stage of analysis of content of obligation, of breach and of remedy, it's a contractual analysis until, supposedly, we get to equitable compensation, at which point it becomes some poor cousin, apparently, of contractual analysis.
Sorry, where do we find that you say, well, it's been characterised as contractual?
Yes.
And it's the rules of causation, etc., are contractual?
Yes.
Where are you actually getting that from?
Well, the characterisation goes back to the original prestige litigation.
Yeah.
The action is characterised as in substance contractual as opposed to a Spanish tort.
So we're back to the arbitrators.
Absolutely.
So, yeah.
Okay. Absolutely. The analysis of contractual for the purposes of causation and quantum, one sees that in I think it's part 2 of issue 5 of Sir Peter Gross's award, where having established the availability of equitable compensation, he looks at defences of causation and mitigation, and he applies contractual principles of causation and mitigation, investigating the arguments of intervening event, etc. So our point
but that might be regarded as non-conventional, might it not? If you're talking about equitable compensation, we know that some people, at least, or there's a body of opinion that would say that the rules are not the same as at common law. I'm thinking about, you know, the whole Peter Millett sort of controversy.
Absolutely, but my point is in relation to this particular obligation, the analysis has been, given its contractual origin and its contractual replication, the obvious manner in which to analyse the content and breach of the obligation and to apply principles, causation, etc., in relation to it, has been contractual. And that's why one sees in cases like the UKSC Nioglu the synthesisation of conditional benefit cases with cases of contractually agreed forum clauses, leading to the different approach to the grant of antisuit. It's treated effectively as a contract case. Indeed, in the Anchor case, which was a conditional benefit case before this court, having set out the facts, no further weight was attached to the fact that it was a conditional benefit case, it was just analysed as a conventional contractual forum case. Now, we say, by contrast with that, the state's case is in fact devoid of principle, at least once you reject its grand unifying theory of consent or voluntary assumption of the responsibility. The state's case, so far as we see it, consists largely of a series of technicalities and of narrow and strange readings of authorities, not least the reading of the J. Bowler, which is the high point of the state's case. They have, we suggest, no answer to this basic question: why, if it is a contractual obligation that's being enforced, should the court, should the club not get a compensatory remedy equivalent to the contractual remedy against the original counterparty? The only discernible answer to that question is privity or lack of consent. And that's an answer that refutes the very conditional benefit principle by which they're bound, because the conditional benefit principle is equity's response to the harshness of the privity rule. So instead what we get
But it's only an analogy, even on your case, to contractual obligation. It isn't a contractual obligation, or are you arguing that it is?
I'm not arguing it's a contractual obligation at law, though one will see when we look at the case of Appellant, that's how it was originally seen. Appellant was a case where it was decided that there was conditional benefit analysis at law, not at equity. But we say the essence of the equitable obligation is the enforcement of the contractual promise. That's the essence of the equitable obligation.
But pushed to its logical conclusion, if you're saying it's a breach of a contractual obligation, you would then end up with common law damages.
Well,
nobody's suggesting that.
You end up with the remedy of equitable compensation that is made available in the same circumstances and subject to discretionary factors that equity will look to, because this is ultimately a regime governed by conscience and therefore discretion. But you look to contract as providing the template for the remedy in question. Absolutely.
But by analogy.
By analogy,
yeah.
Yes. Now, these technicalities, I would suggest, are particularly striking when you consider two things. Consider first how we got here. We got here because of the state's immunity from anti-suit relief. And that means that the primary remedy of an injunction was not available, and it means Section 50 damages in lieu weren't available. What would the response have been as against a state as contracting party, the party into whose shoes the conditional benefit party steps? The response would simply be contractual damages and a contractual indemnity for your breach, please. And the only question we suggest is why the same analysis, through the guise of equitable compensation, with the qualifications I give to my Lord Burrows, why that analysis should not prevail in a conditional benefit case. And then consider, secondly, that none of the cases on which the states build their case, the J. Bowler, the Yusuf Setnioglu, etc., in fact grapple with anything that remotely resembles the issues in play here, namely what remedies should be provided against a party intent on repeatedly breaching its equitable obligations until it's received full satisfaction from a Spanish judgment only obtained by ignoring the court's prior declarations. Cases on anti-suit relief, where an injunction is the only remedy sought, tell one little, I would suggest, about what equity will require when such primary or default remedies are, for whatever reason, unavailable or incapable of putting an innocent party back to where they were before the equitable breach in question. And we suggest that the recent history of equity, be it Wolverhampton, be it Guest and Guest, doesn't generate the sort of tabulated legalism the states urge as to an understanding of the jurisdiction to grant equitable remedies. It's a story instead of flexibility, of innovation, and, where such is the appropriate step, it's even a story of replication or coherence with, or analogy to, the common law. And to describe the practical relief that the club has received to date, namely declarations of non-liability, as sufficient when the state plainly reserved the right to seek enforcement of the judgment to its full recoverable cab, is, I would suggest, formalism. Without the relief granted by the two arbitrators, the club remains exposed outside England. With the relief granted, its position is very substantially improved. Now, that's a fairly lengthy introduction. I've got 5 topics going forward. Topic 1 is to address the general law on equitable compensation and remedies, starting with AIB. Topic 2, I'll try to answer the state's grand unifying theory of consent or voluntary assumption of responsibility. Thirdly, I'm going to analyse the conditional benefit case law, starting with the modern statement of Atlantic Confidence, but I am going to take you, I'm sure you can't wait, to the mining and the property estates cases to show you that the law actually in this respect, or equity in this respect, has always been concerned with the grant of monetary relief, where that's been the essence of the remedy required. Fourthly, I'm going to address the Lord Cairns Act reasoning. That's the sort of purely jurisdictional bar reasoning of the Court of Appeal. And then lastly, I'm going to address very briefly the assortment of rag-bag arguments that have been made for special pleading in relation to direct action conditional benefit cases. Then after lunch, as you know, Mr. Thompson is going to address you in particular on the topic of comity in ground 2, even though it's been invoked in relation to ground 1, after Mr. Han has addressed Sharp and Viterra. So topic 1, remedies in support of equitable obligation. And straight away, let me acknowledge the difficulty in abstracting general propositions about the availability of equitable compensation. Being candid, there is no case or textbook that we know that seeks to synthesize across the various pockets of case law on equitable compensation. And that's because where equitable compensation arises as a remedy, it does so in such pockets. And so beyond an analysis of what the particular obligation is at play and why that particular obligation requires equitable compensation, there is no case containing any kind of unifying theory as between the different pockets. And that absence of synthesis, I'd suggest, is a function of 2 things. Firstly, it's a function of the comparatively recent accelerated evolution of equitable compensation as a remedy for equitable wrongs. And secondly, it's a function of the fact that if equitable compensation is awarded as a proper and just remedial response to a particular form of breach, then equities differ and the case for and against equitable compensation themselves differ. And since the equities differ, so too will the approach to equitable compensation across these pockets. Beyond that, our case rests on 4 propositions.
Why isn't the synthesis that you can have equitable compensation for equitable wrongs? I mean, as I understood your submission, you would say equitable obligation in this context could be regarded as an equitable wrong. You can't take the benefit without the burden, as I understand it.
Yes.
So are you saying, oh, well, it's not even correct to say, as a general proposition, that you can have equitable compensation for equitable wrongs?
No, I don't think I do say that, my lord. That is, on the other hand, a proposition of pretty universal generality. But the four propositions I was going to make, and I think the first one comes very close to what my lord just put to me, were these. The first is the court, in fact, has inherent jurisdiction to award equitable compensation in relation to equitable rights and wrongs. So, in a sense, we say yes to your question. Secondly, we say the remedy is an evolving one, and the categories of case where such a remedy is an appropriate response is certainly not closed. Thirdly, we say the necessity for or availability of equitable compensation as a response is as a reflection of the nature and purpose of the equitable duty breached. Equitable compensation must be required to do justice given the nature of that equity and the consequences of its breach. And then fourthly, we say equitable remedies should cohere with remedies at law, particularly where they perform the same function. And thus, where the equitable obligation is derived from or modelled upon an obligation at common law and serves the same or similar functions, the availability of relief and the compensatory approach should be the same, whatever the source as a matter of history or the label, equity or law, that is applied to that self-same obligation. We say those third and fourth propositions are reflected in the case law. Indeed, they're all visible at the get-go in the AIB case. Maybe that's where we can start our analysis. Electronic bundle, tab 39, page 966. And as my lords will recall, this was a case about the correct approach to the award of equitable compensation as a remedy for breach of trust. Lord Reid cited from the Canadian case of Canson, and at paragraph 90 and following, page 997, identified three important points arising from the case. See that in particular at the passage at 92 and 93, where Lord Reid is in effect saying that in order to decide upon remedy, you must look closely at the nature of the obligation involved, and then the different rules as to assessment of loss and remedies that may apply depending on the nature of the duty involved. And that approach implies a varying approach, even in equity, to reflect the nature and purpose of the particular equitable obligation at issue. And that's why there are different remedial responses in relation to breaches of the three broad different categories of fiduciary obligations: stewardship, honest dealing, and the use of care and skill. And then, if you go on to 119, page 1003, having cited Lord Justice Millett in the Bristol and Moffew case, at the end of paragraph 119, he makes the point that it's necessary to consider the specific characteristics of the obligation in question, here care and skill, and the respects in which it resembles or differs from the obligations arising in other areas of the law, such as duties of care in contract or tort, in order for the law governing the liability for the breach of these various obligations to be coherent. So there are two themes. Look carefully at the special characteristics or specific characteristics of the equitable obligation in play, and look at the extent to which it either resembles or differs from obligations in other areas, say in contract. Those principles are then applied to the specific question before the Supreme Court, leading to the remedial differences as between the liability of trustees for breach of trust and liability in tort and breach of contract. But then look at what Lord Reid says at the end of 138, at page 1008. And in particular, the passage, as the case law on equitable compensation develops, however, the reasoning supporting the assessment of compensation can be seen more clearly to reflect an analysis of the characteristics of the particular obligation breached. This increase in transparency permits greater scope for developing rules which are coherent with those adopted in the common law. To the extent the same underlying principles apply, the rules should be consistent. To the extent that the underlying principles are different, the rules should be understandably different. Now, that approach we suggest of examining the nature of the particular equities and fashioning the remedy accordingly is really no more than a reflection on the plane of remedies of the general approach of equity summarised by this court in the Wolverhampton case, electronic bundle tab 110-2857, as summarised in our written case at 34, pages 71 to 73 of the electronic bundle. And that approach of focusing upon the equitable obligation and asking what response is required to protect the equity is also fully supported by the approach of this court in other areas of breach of equitable obligation. The most obvious example is the proprietary estoppel case of guest and guess, where a promisor has resiled from an informal promise to transfer land to the claimant in the future. Equity will intervene to provide an appropriate remedy, if necessary, by way of equitable compensation, to satisfy the equity of the promisee who has no protection at law. That's the approach of Lord Briggs and the majority. To the extent that there was a disagreement in the speeches, it was not as to the remedy, it was as to the fundamental aim or purpose of the underlying equitable obligation protected by proprietary estoppel. Was it to satisfy the equity of the promise, that's the majority view, or was it to protect against detriment? That was my Lord Legate's approach. But tellingly, once the breach of the equity had been identified, there was no dispute between the majority and the minority approaches as to the use of equitable compensation as the tool with which to do the justice required in the circumstances of the case. In circumstances where, in particular, compelling full performance of the promise early, effectively, before the parents had died, was in either case inequitable. Indeed, on Lord Legate's approach, it was only equitable compensation to a detriment that could be used to fashion a remedy to protect the equity. And all of this, as you can see from the speech of Lord Briggs at page 1786 of the electronic bundle, paragraph 4 onwards, is about equity responding to an injustice to which the law is otherwise blind by restraining the...
Can you give me the page again, sorry?
Yes, 1786, my lord.
Thank you.
It's putting right a justice to which the law is otherwise blind by restraining the rigid application of legal rules where their implementation would be unconscionable. And the rule thereafter identified, the first rule, is that a promise is not enforceable unless it's made part of a contract. So this whole remedy is part of an equitable response that is designed to temper the rigidity of privity of contract to address the unconscionability that the rigid application of that rule would produce. So, to the extent the states repeatedly rely on the strictures of common law and say that you can't get equitable compensation because it would rewrite privity of contract or it would be tantamount to a novation or so forth, that clearly cannot be any kind of answer where the equitable remedy being sought is one that's part and parcel of equity's response to the inadequacies of privity at law.
You'll have to show, though, won't you, that there's a difference between this approach and a third party enforcing a contract, because otherwise it's just changing the label and there's no substantive difference between what you're doing. I mean, either this principle can be distinguished from one that infringes on privity of contract, or it can't. And if it can't, then calling it equity, it doesn't change the nature of what we're doing.
it does infringe on privity, and that's why the authorities describe it as an exception to privity, the rules on privity. That's exactly what it is. It's an equity-based exception to the rules on privity of contract. But once the obligation is triggered, and there are equitable preconditions for its triggering, conscious choice of the taking of the benefit being the first and foremost, and secondly, a strict requirement of indissociability of benefit from burden. Effectively, the benefit is conditioned by and inextricably interwoven with the burden. Once those conditions are met, then equity does enforce the obligation just as law does. And that's why we'll see when we come on to the mining cases, what happens is parties found causes of action based upon the breach of the equitable obligation, and they sue for money. They actively go to court and sue for money for arrears of maintenance and matters of that kind. So at that functional stage, once the equitable trigger is pulled, the obligation is functionally the same as an obligation in contract. The point that we make about guest and guest is here.
Can I just be absolutely clear? You've used the phrase twice. The equitable trigger is pulled.
Yes.
What do you say is the precise moment at which the trigger is pulled?
The moment at which the trigger is pulled is the point at which a party chooses to assume a benefit which comes with an indissociable burden.
And what does that mean on the facts of this case?
It means on the facts of this case, starting proceedings based upon the policy of insurance in Spain. That was the trigger that was identified as missing in the Atlantic Confidence case by Lord Hodge, but is very obviously present in this case. And as the earlier courts conclusively found. I mean, that's why I started with saying there's no debate about the existence of the equitable obligation, because Spain took steps that were sufficient to indicate its taking of the benefit, and with it the burden of the forum clause. So we say guest and guest is another illustration of equity.
And on these particular facts, at the very moment in which you're taking the benefit, you are immediately infringing the burden aspect.
Yes, and that rather resembles the arguments that were made in the Mitchell case as to whether or not the same act may generate both the assumption of the obligation and its breach. And this court, my Lord Borough's dissenting, concluded it could.
Which case was that?
Mitchell and Al-Jabbar. Yes, yeah, and as Mr. Hancock reminds me, there's not really any doubt here anyway, because the 2015 proceedings...
Are you sure I was in that case?
I'm pretty sure.
Well, Burroughs has forgotten his dissent, convenient, but he was in a minority, convenient.
Sorry.
It was the case about... yeah, well, I'll come back to it. I'm come to it in due course. Yes, so the 2015 proceedings... Wasn't it? Oh, I'm going wrong. You remember better than I do.
Thank goodness for that. That's pretty
well, far better for my memory to be impugned than my Lord's.
But you say we can find some help from that case, can we?
Yes.
On this triggering being one at the same time as the...
Yes, yes, because that was one of the two issues in the case.
What was the case, just so I can make a note?
Yeah, it's in the supplementary bundle, tab 5 of the supplementary bundle. That's the reason why we added it to the authorities. Yes, yeah. As I was saying before, I got distracted by Mitchell. In the 2015 proceedings, there was a very clear declaration of the obligation to arbitrate and of the consequent non-liability flowing from the pay-to-be-paid clause that preceded the Spanish judgment, and Spain proceeded with further steps in the Spanish litigation, culminating in the Spanish judgment, in the teeth of that declaratory relief. So even if there was a need to identify separate and later acts constituting breach, they were present in the run-up to the Spanish judgment. So a guest and guest is an illustration of equity intervening to provide a monetary remedy where the common law would not, in support of a flexible response tailored by reference to the particular equities arising, including equities of enforcing promises, and using equitable compensation as a remedial option where the primary remedy of enforcing the promise is either inappropriate or unavailable. And then a last example is, of course, the Bristol and Matthew case itself, because there again, Lord Justice Millett emphasises, and it's the passage at 16G 1198 in particular, that differences between equity and common law shouldn't be insisted upon for historical sake. They should only be insisted upon where they reflect some meaningful difference between the underlying common law and equity. And therefore, he says, culminating at 16G, that common law and equity influenced each other, and to get today the substance of the resulting obligations can be more significant than their particular historical origin. Then if one goes on to 17G, you'll see he says, although the remedy which makes equity makes available for breach of the equitable duty of skill and care is equitable compensation rather than damages, this is merely the product of history, and in this context, in my opinion, is a distinction without a difference. Equitable compensation for breach of the duty of care and skill resembles common law damages in that it's awarded by way of compensation to the plaintiff for his loss. There's no reason in principle why the common law rules of causation, remoteness, etc. should not be applied by analogy in such a case. But there is this underlying search for coherence, and where the nature of the obligation is the same, the remedy should be the same. And that is obviously particularly important where the nature of the equity here is to enforce the underlying contractual promise by treating the successor standing in the shoes of the original party as in effect, in substance, that party. So that's the general approach. Topic 2, the states say effectively, no, you've got to point to something else as well. There is some form of grand unifying theory of the law of equitable compensation. You've got to show, for instance, see paragraph 65 of their case, that a party has voluntarily assumed obligations and or that there is an unconscionable breach of such an obligation, or the defendant has dishonestly assisted in breach of fiduciary obligation. And then later they pin the availability of equitable compensation to whether the relevant duties were fiduciary in nature or closely adjacent or materially similar to them or concerned an equitable interest in property. None of those considerations explain the totality of the areas in which the law of equity provides equitable compensation. Let's take voluntary assumption of obligations first of all. The availability of equitable compensation is not limited to cases of voluntary obligation or promise or consent. And that's because in equity, compensatory remedies respond not only to breaches of duty which are voluntarily assumed, it certainly does that, but also to ones that are imposed by equitable policy, because amounting to a recognised species of unconscionability or wrongdoing. And the most obvious example of that is breach of confidence. The equitable obligation of confidence is not imposed necessarily by any assumption of responsibility or promise or consent, it can be so, by contract, etc. It's imposed because of the objective demands of conscience. And the authority for that is Vestergaard at 22, electronic bundle, page 2758. The circumstances to impose the duty in equity turn critically on the nature of the information, an objective question, and notice to the acquirer of confidentiality, leading to a test of whether the recipient knew or ought to have known the information in question is subject to another's reasonable expectation of confidentiality. See Vestergaard at 23. And as my Lord Snowden will recall from the recent Corrigan case, citing Seeger and Copydex, and we put that case in the bundle, supplementary bundle at tab 4, and the relevant passage is at page 32, Seeger and Copydex says, in terms, the law on this subject does not depend on any implied contract. It depends on the broad principle of equity that he who has received information in confidence shall not take unfair advantage of it. Now, the states don't dispute that equitable compensation is available in this class of case, but they make 3 points. The first is to refer to Mr. Justice McGarry's statement in Coco and Clark that the equitable jurisdiction is ancient and it's the cousin of trust. And we suggest that that point goes nowhere, because all Mr. Justice McGarry is saying no more than that confidence is a well-recognised historical source of equitable obligation, not that confidence and fiduciary duties are based on the same underlying principle. The second point they say is, well, the need for notice in a confidence case shows, and I quote, there is an alignment between the equitable obligation of confidence and fiduciary obligations, but notice doesn't amount to an assumption of an obligation. It defines instead the factual or objective circumstances in which equity will impose an obligation, because it would be unconscionable to let a party act otherwise. A trespasser to a private event may be just as bound as a party buying a ticket to that private event with confidentiality conditions written into it, even if a trespasser never intended to respect the confidence. Indeed, the whole reason they may be covertly accessing the property is to report it free from those types of strictures. The states also refer to a passage in Toulson and Phipps where the authors refer to the decision of the Court of Appeal in our case as giving rise to potential to doubt equitable compensation in breach of confidence because of the Lord Cairns Act reasoning. The passage then goes on to state there are obvious differences between such a duty, conditional benefit, as such a duty in confidence and the equitable obligation to arbitrate. And I suggest that advances matters little because, of course, equities can differ. And the question is, as I've already said probably too many times, the question is what the nature of the conditional benefit equity is and whether it requires equitable compensation as a remedy. But the passage in Toulson and Phipps, I do commend it to you because what it does do is flag the universality of the law.
So what page are we talking about?
It's page 3099 to 3100, my lord. It's paragraphs 6209 to 6211. What the passage
is it? I had always understood, but I may be wrong,
yes,
that although it might seem a bit odd, there is no case that has awarded equitable compensation for breach of confidence. Is that wrong?
Well,
and if so, can you give me the case?
Mr. Justice, I'm just about to come on to it. Mr. Justice Arnold has concluded that there is such a jurisdiction to award equitable compensation. That's the Force India case.
Sorry, I didn't catch the name of the case.
Force India. It's the motor racing team.
Because for a long time there was it was seen as equitable damages, i.e. Lord Cairns' Act.
That's precisely the issue with which Mr. Justice Arnold grapples with in Force India.
Okay, thank you. But is that the only authority?
There's Canadian Supreme Court authority.
No,
on the
authority
topic.
In this jurisdiction?
In this jurisdiction, no, there isn't. But the interesting thing about the Canadian authority is it grapples both with the availability of equitable compensation outside Lord Cairns' Act, and it deals with the argument about Lord Cairns' Act as an ouster of remedy.
Okay. Are you going to take us to Mr. Justice Arnold?
Yes.
Thank you. And the Canadian authority?
Yes. What the passage in Toulson and Phipps does do, however, is flag the universality of the Lord Cairns Act reasoning, because if Lord Cairns Act is indeed an exclusive remedial code, making Section 50 the only remedy available, that's going to bite wherever the court is otherwise minded toward equitable compensation in support of an equitable obligation. It can't be reasoning that somehow confined only to conditional benefit case. Another obvious example where consent plays no role is dishonest assistance. Here we say the only analysis is that the relevant equitable analysis and the award of equitable compensation stems from the nature of the wrongdoing in question and the fact that effectively, by becoming an accessory to a wrong, you're stepping into the wrong in the same way as the primary wrongdoer, at which point the award of the same remedy, or remedies as you would award against the primary wrongdoer, makes sense on the plane of coherence. And even if the touchstone in such cases were close adjacency or close assimilation, as the states suggest, with the person who has assumed an obligation, then that is precisely what one has in the case of conditional benefit. Rather than an accessory, they are a successor, and the third party has stepped into the shoes of the contractual party and thereby assumed the indissociable obligation. And then the next category is de facto trustees or fiduciaries, trustees de centor. That's the Mitchell and Al-Jabbar case mentioned earlier, supplementary bundle tab 5. The case was whether or not a trustee, whether a person had assumed the office of a trustee or a fiduciary, even though they hadn't been appointed to the relevant office, and in some cases, even though they hadn't agreed to assume any fiduciary obligation. And the critical thing is that effectively the case for the appellant was being made that there couldn't be a fiduciary obligation because there had been no prior consensual assumption of responsibility. You can see that from their counsel's submissions reported at page 762, that's page 49 of the supplementary bundle. And then you can see it at paragraph 32 of the report, that's page 61 of the supplemental bundle. That argument about voluntary assumption of obligation is then unanimously rejected at 31 to 56, the whole of which merits reading, but I would suggest the key points are to be found at paragraphs 39, page 62, 42, page 63, and 50, page 66. And the reasoning comes down to this. It's that in certain circumstances, by reason of objective features and as a matter of policy, equity will treat someone as having undertaken to act as a fiduciary, whether or not they so consent. And the feature lighted upon as triggering that analysis is the practical stepping into the shoes of a party owing a duty to act like a fiduciary. What mattered was that the defendant purported to exercise a power which was fiduciary. And it was that act that then triggered the obligations that ran with it. And we say, once again, the position is entirely analogous here. Where the third party has not agreed to contract, but has sought to exploit a contractual right and thereby step into the shoes of the original party, they should be fixed with the same burdens as the original contracting party. And the passage at paragraph 43, page 64 of the supplementary bundle, citing the case of Saw and Ashwell, could not be clearer that actual consent is not required. It's a question of policy. You'll see exactly the same reasoning on the topic of consent in relation to assumption of a burden under the conditional benefit principle in the through transport case, in Prestige number 2, in Prestige number 4. And I'll take you to the findings of the court about consent in this particular litigation. So what that shows is that even if there is some form of consent theory unifying these cases, consent in this case is present in a sufficient form to trigger the operation of the conditional benefit principle. And once consent in that form is so present, then there can't be any further argument about it in any event. Even on the state's own case, that provides a sufficient normative basis for equity's intervention and applies whether the remedial response is an injunction or a monetary remedy. I'll take you to what the court has said about consent when I get to the forum case.
So you say, even if there is some idea of voluntary assumption of responsibility, here we have a necessary consent to the benefit, and that in a sense might be regarded as assuming the responsibility to abide by the burden.
Exactly so. Go back to my Lord's question about what the trigger conditions are. The trigger conditions are a voluntary taking of the benefit. And the case law is very insistent that there has to be a genuine ability to choose or decline the benefit in question. A voluntary taking of the benefit and the indissociability of the burden with the benefit. Once those conditions are met, the policy is you can't choose the plums without the duff. If you choose to take the plums, you are to be taken as a matter of law, as a matter of legal policy, to have consented to the duff. That is the consent that equity is looking for in these circumstances. Now, the last label that's floated in this connection is unconscionability. And insofar as unconscionability is required, we say yes. But the unconscionability is that very act of trying to take the plums without the duff. And that is unconscionable is precisely what the courts say in the forum cases. So in the J. Bowler, and we'll come back to the passage in particular, at 2272, page 286 of the original report, Lord Justice Hobhouse says that what is entailed in trying to take the plums without the duff is unconscionable conduct. That's why there was a jurisdiction to grant, even on the aerospatial approach he applied, an injunction as a matter of equity. And likewise, in the Yusuf Setnioglu, Lord Justice Maud Bick, paragraph 55, also analysed the behaviour of trying to take the plums without the duff in terms of unconscionability. It's precisely because it's unconscionable to choose to take a benefit to which a condition is linked without honouring the benefit that equity intervenes. So it's no surprise to see the same conduct labelled unconscionable. Sorry, I misspoke. So, no grand unifying theory. Can I then turn to my topic 3, the nature of equitable obligations arising from a conditional benefit? So this is the forensic examination of what the conditional benefit principle does, for the purposes of applying the AIB test for applying the Wolverhampton framework. And the starting point is this court's decision in Atlantic Confidence, tab 43, electronic page 1104, and the speech of Lord Hodge, paragraphs 22 to 29. It's important to emphasise this case was not a remedy case. The issue in this case was whether sufficient conduct had occurred to make the third party, an equitable assignee, a successor to the written obligation to arbitrate of the original party, original obligation of an exclusive jurisdiction clause. So the case in that case was only about had the trigger been pulled by conduct sufficient to then fix the party with the burden. And Lord Hodge identified, citing Lord Justice Hobhouse with approval from the J. Bowler, consistency with the terms of the contract, that's how it was put, as the key touchstone for the imposition of the equitable obligation once conduct sufficient to assert the right had been shown, and once you thereby became a successor. So the schema Lord Hodge identified from his review authority was effectively, was there a contractual burden, that indissociable contractual burden that conditioned or qualified the contractual benefit? That's the test insisted upon by Ronan Stevens, reformulating Housel. Was the benefit clearly assumed by being invoked by the successor for its benefit? And therefore, was it as such equitable for the successor, here the assignee, to be subject to those conditions? And that schema, as summarised in many other cases, there's Davis and Jones is a very good case unpacking all of the requirements of the conditional benefit principle. That schema accurately encapsulates the rationale of conditional benefit in all cases. But it is worth doing a little bit of history, if you'll forgive me, because, well, for two reasons. The first is that the conditional benefit analysis and conditional benefit obligations, as synthesised by Roan before Atlantic Confidence, have been around since the mid-1800s rather, to derive money obligations and money entitlements, as well as injunctive entitlements. There's absolutely nothing defensive or defence-only about the obligations created once the equitable trigger has been pulled. A more accurate way to describe the obligations, I would suggest, is reactive rather than defensive, because they are conditioned on a party first choosing to invoke the benefit. The second thing of note is that all of the forum cases involve a fact pattern in which the only question was whether the arbitration clause was enforceable against the third party, and the only relief sought was an anti-suit injunction. So in none of the anti-suit cases was anyone asking for monetary relief. The object was instead to prevent damage by early days injunctive relief. And it's, as such, I suggest, unsurprising that there's no discussion of monetary remedies in those cases. So with those two, let's start with the mining cases. The details differ, but they share a common pattern. An estate is divided into the surface and subjacent mines, with rights to mine being granted, subject to covenants to pay compensation for any damage to the surface, and in one case, subject to a condition, that's the West Houghton case, requiring the covenantee to repair and reinstate damage to buildings. Mining activities then occur that cause damage to the surface, and claims are brought by plaintiffs with interest in the surface against defendants who are relying upon the benefit of the entitlement to mine in circumstances where there is no direct contractual relationship and no privity between the parties. The question is, where the mining interest seeks to rely on its rights to mine, as against the plaintiff, is it bound to comply with the covenants, and if so, what is the plaintiff's remedy, given that there is no claim in contract? And in each of these cases, notwithstanding the absence of privity, the court held that the defendant who enjoys the benefit of the right to mine must comply with the burden. And the court went on to grant monetary relief to enforce that analysis. Now, the first case, as I mentioned, is Aston and Seddon. It's a case that is post-Lord Cairns Act, but pre-Judicature Act for the purposes of transitional provisions. It's right on the effectively the year of the Judicature Act, but it's treated as a pre-Judicature Act case, as footnote 2, page 1060 confirms. And it's a very odd case because the conditional benefit analysis is at common law, not in equity. That the doctrine in its early days hovers on the boundary between law and equity speaks very strongly, we would suggest, to the contractual content and the nature of the equitable obligation in question. In fact, you can see it almost as a fork as to whether or not the response to the inequity in this situation is provided by the law of contract or the law of equity. What you can see from page 500 of the report, 1058, is that what happened was an injunction was refused by the Master of the Rolls in Chancery, pre-fusion, on the basis that the plaintiff should go off and bring an action at law for damages. So they were effectively saying the place for your remedies in damages. And the case then came on before the Court of the Exchequer Division, the precursor to our KB division, by way of case stated, asking whether the plaintiffs is or are entitled to recover compensation from the defendants for damage to the mill and premises. And the answer was a resounding yes. You can start with Baron Bramwell, page 503, 1061 of the electronic bundle. The key passage is at 503 to 504, 1061 to 1062. And you can see in the culmination of page 504, his conclusion, first of all, that there was consequential obligation to arbitrate, so that went with the enforcement of the obligation as well.
Where are you? Sorry.
Page 1061 to 1062, the passage starting near the bottom of 1061, the defendant is an assignee of the mines, and he has under and by virtue professedly, unless it is so, it is a tortious act on his part, of that licence so granted to him, worked his mines in such a way as to let down the plaintiff's surface. And it's that passage through to over the page above, I do not know. And Baron Bramwell, in hyperbole, that I can fully get behind suggests it would smack of utter unreasonableness if the burden weren't enforceable in these circumstances, enforceable at law. It seems to me plain they are bound to make that compensation. And so what he does is enforce the covenant to compensate against a party with whom there is no privity of contract, because it would be utter unreasonableness to do otherwise.
So the remedy granted was the payment of some money?
Compensation.
At law.
At law. Yes. At law. You can see, to like effect, Baron Cleasby at 507-1065. His analysis of how an action at law could be maintained, and he makes an analogy with a rent charge. And then at 1066...
1065, you say?
1066, he says... I'm sorry, my lord.
Your first reference to Baron Cleasby was 1065, was it?
Yes, my lord.
Thank you.
That's where his speech starts. But it's the passage at 1066 that's the crux of it. And the reason he said given is the very excellent one, certainly equally applicable to this case, for it's the only reason given, for qui sintet et quemodium sentiri debet et onus. If you take the benefit, you must also bear the burden. There is no liability arising out of contract. The only liability arises out of this, that the man who has enjoyed the land, that's where I say there's only an analogy. In respect to my Lord Burroughs' point, it is an analogy, not a case in point, because the man has enjoyed the land, and during that time he has enjoyed it, certain liability and risk of respect to it have accrued. And then if you go on in the next passage, this emphasises the point of choice that all the other authorities like Davies and Jones emphasise. Then the law says you ought to bear the burden because you have enjoyed the land. There is no necessity imposed. It is not a burden in that sense. It is optional with him whether he exercises the right or not. And that's the crux of the equitable trigger. It's a genuine voluntary choice to assume the burden. If you do so...
Why is it an equitable trigger? He's not mentioned equity at all. This is a case on law.
It is, my lord, but it's this reasoning that's then adopted in the later cases. Which
it's not reasoning, it's just stating the answer.
Well, it's stating the answer based upon a principle of benefit and burden.
But it doesn't support any argument that you're putting forward in relation to equity.
No, it doesn't, my lord. And I hope clear that the analysis starts at law. What then happens is that this analysis is taken up by the courts in equity. And the later mining cases, Braun, Apston and Seddon, are exactly the same conclusion, but in equity. I apologise if I was unclear about that. So where we start is conditional benefit reasoning in law, albeit not in equity, and an emphasis upon voluntariness, the option to enjoy the right being taken. And that reasoning is then endorsed by short speeches in the Court of Appeal at 1066, Lord Justice James, 1077, Lord Justice Mellish. The next case, some 20-odd years later, is the Chambers Colliery case in Highwerold, page 1312.
So the Court of Appeal, you say, just affirm that? Yes,
there's much less substance in their reasoning.
So which page, Chambers Colliery?
1312, my lord. The facts are in the same basic pattern, and what happened is that Lord Watson upheld the first instance order requiring payment of compensation as required by the covenant to which the right to mine was subject. You see that at 270, 1314 and following. And the key passage is at 1316. That reasoning in our submission is a second example, this time from the House of Lords, where conditional benefit reasoning is imposed. The covenant to compensate is clearly being enforced, and it's held that the third party is bound to compensate the plaintiff, and the order made, ultimately, is for compensation. And whilst not expressed so in terms, a reflection of the times, we say, in modern terms, that's best analysed as an award for equitable compensation.
We say that now, but did they say that then?
No, that wasn't a terminology or a label
So
in
that's
use.
a second case which doesn't actually support the proposition that there is any equitable.
Well, it's the remedy that we
Obligation.
would today call equitable compensation. I don't suggest.
Well, you might.
Well, I do, and my lord is either with me. In
Well,
relation to it
I
being
just wanted to know
substance the
whether, in
same.
fact, it's authority for the proposition that there is equitable.
Can you help me, Mr.
Obligation.
Delamere, with the precise passage on 135?
Yes, it's a 270 and following, but in particular 1316, the bottom paragraph at 1316.
Final paragraph.
Yeah.
Thank you.
It's the passage starting, it was argued that the respondent was not affected by the covenant in question. And it goes on, the argument appeared to me to proceed upon a misconception of the true nature of the covenant. In my opinion, it does not profess to impose a burden running with the lands. It's an inherent qualification of the coal owner's licence to work with the effect of letting down the surface, and provides that he shall not do so except upon the condition of compensating the owner for the time being of buildings which are injured by his operations. And then the third case...
It's a bit different, isn't it? Because the obligation that is implied or is to pay compensation. There's not a question of damages being or something similar to damages being awarded for breach of an obligation.
Yes, it's a monetary covenant.
Yeah.
And the states say that that makes all the difference in terms of the analysis. And we say that the third case I was going to take you to, West Houghton, shows that can't be right, because in West Houghton, there were both obligations to pay compensation, and there was a non-pecuniary burden in question. West Houghton is at 2812.
Can I just be clear that I've understood the point Lord Legate is making? The covenant itself specified that there was a monetary remedy.
It's a covenant to provide compensation if the land is let down.
And I think there was a similar covenant in the
There was.
Aspen case.
Indeed.
Yes.
So you have a covenant that's expressed in monetary terms, like you shall compensate.
Yeah.
The third case, West Houghton, involves both such a covenant and a non-pecuniary condition, which was a condition to repair buildings. And precisely the same analysis is applied, citing Aston and Seddon in particular. You'll see that at 2825. Before the court then awarded damages, or basically breach of the covenant to pay compensation, and for breach of the condition to maintain the vehicles and the buildings and repair. You see that in particular from the order at 2829.
Sorry, 2.
2829. At the foot of the page, and you can see that what's ordered is a declaration of liability to pay money, an inquiry as to damages, and an order that the defendants do pay the amount certified in the inquiry, and damages to the land and buildings. And it's the and buildings that's relevant, because it's the buildings to which the covenant, the non-monetary covenant, in other words, the covenant to keep the buildings repaired, pertains. And the damages are said to have been suffered by reason of the defendants not having performed their obligations under the mining lease, i.e. their obligations to repair and reinstate the buildings that were damaged. Those are the mining cases. There's then a suite of cases about property and estates. And these cases are all clearly decided in equity. It's the line of authority that starts with Halsall and Brazell and culminates in 3 modern Court of Appeal authorities, Thamesmead, Wilkinson and Elwood. They too have a similar fact pattern. The successor entitled to a deed has a right to use certain services on a housing or industrial estate or a holiday park, subject to an obligation to pay contributions or maintenance fee in respect of those services. And having enjoyed the right, having used the roads or the sewers or the holiday park amenities, the successor in title was held obliged or ordered to pay the money due under the deed. And what these cases show is that the breach of the burden imposed by the conditional benefit principle does indeed result in positive remedies, namely the requirements of payment of money. And it's typically payment of arrears. Now, there's an evolution in these cases, important one. In Halsall, the conditional benefit reasoning is applied by reference to the whole of the burden under a relevant deed. So once you took a benefit, let's say the use of the roads that was made available to you by the deed, the reasoning went, everything else went with it. And the argument in the subsequent cases is about the promenade, and the maintenance of the promenade. Roan and Stevens then rejected that, if you like, deed-wide approach of approbation and reprobation, and emphasised that the burden must be indissociable with a particular benefit. That's the main impact of the Roan case. And it's that later focus on the particular benefit and whether it's been consensually taken that then informs the later estate cases, Thamesmead, Wilkinson and Elwood. And what you'll see in each of those cases is a close forensic investigation of what benefits have been taken and what indissociable maintenance burdens thereby are triggered and run with them. Now, Thamesmead is a particularly striking example, page 2437, as no injunction was sought, no Section 50 damages were sought. It was just a case seeking payment of arrears of sums claimed as maintenance. So much is clear from page 2441 to 2. And of the overall sum claimed, only £41.65 survived in the judge's analysis because that was the only part where the burden related to benefits that the defendant had taken. The defendant's counterclaim, in that case for a declaration that the obligation was unenforceable as a positive covenant, that failed. And the result was that there was an obligation to pay maintenance in that sum, and he could be sued, the defendant could be sued for his share of the works that he'd paid for the right so enjoyed. And that was essentially the same analysis that then was applied to the bungalow owners in Wilkinson, and indeed in relation to the industrial estate unit owners in Elwood. And again, in that case, the claim was for money alone. No injunction was even sought. See page 1508. Now, the states accept that these cases show that monetary remedies can be awarded for breach of the conditional benefit principle, or as Lord Justice Patten put it in Wilkinson, page 2835, paragraph 27, once the conditional benefit applied, they incurred a liability to perform a positive covenant, which could result in a money judgment or compensatory order. That's a pretty fundamental concession to make in relation to a doctrine which the Master of the Rolls below concluded does not give rise to a cause of action of a conventional kind. That's correct.
Can you just give us the reference, or give me the reference to Lord Justice Patten again?
Yes, of course, my Lord. 2835, paragraph 27. So once you incur a liability to perform a positive covenant, and once a cause of action is...
I think it's 2836, paragraph 27.
Oh, I'm so sorry, my Lord. That's alter my notes. That's a pretty fundamental concession in relation to a doctrine that the Court of Appeal, the Master of the Rolls below, concluded does not give rise to a cause of action of a conventional kind. That was his conclusion at paragraph 218, page 208 of the bundle. That conclusion is, with respect, wrong, and it's impossible to reconcile with both the mining and estate cases, some of which, Halsall and Thamesmead in particular, were cited to him, and he did not address. They were, on any analysis, cases where a cause of action, or payment of amount of money, arrears, was founded upon the obligation made enforceable by the conditional benefit principle and only the conditional benefit principle, just as Lady Justice Gloucester rightly said it could be in the case of Udana. Yet this no conventional cause of action tenet is a key plank of the Master of the Rolls' reasoning, as paragraph 221, page 209 shows. And so, if it's wrong, as it is, his reasoning must fall away. Not least because it also changes the focus of his subsequent ouster reasoning at 219.
Before we go any further, I mean, these cases you've said are indisputably equitable compensation cases. I mean, why are you saying that? I mean, are you pointing us to something that makes that clear?
It's all conditional benefit analysis. And Housel is the stream of conditional benefit cases, which the later conditional benefit cases, like J. Bowler, say, are now accessed in forum cases. It's all part and parcel of the same conditional benefit analysis in equity. So for instance, Roan and Stevens, the other classic case, is clearly a conditional benefit case. There was no privity of contract. There is no privity of contract in any of these cases, and the obligation is analysed in each and every circumstance as effectively arising in equity.
Well, is it, or is it that this is an exception to the general rule that a non-party cannot enforce a contractual obligation?
Well, with respect, my Lord, I'm not sure that's a question with a difference at the end of the day, because at the end of the day, what we seek is enforcement of a monetary remedy in the circumstances of this case. And if you were to ultimately label it at law, go back to Aston and Seddon, my clients would be perfectly content with that. We don't hang ourselves on the labels. What we say is what in substance is happening here is that equity is intervening to enforce a contractual obligation. That's what's happening. And the remedy for that should in substance be a remedy like damages to put the party in a position it would be but for the breach.
But I suppose what I'm pressing you on is you're saying that the very principle of benefit and burden is an equitable principle.
In this manifestation, yes, my Lord.
Therefore, where a monetary remedy is given, you are assuming that that is equitable compensation.
Correct.
And not damages at common law.
Correct. And not damages under Section 50 either.
And not damages under...
And that's why...
But I suppose what I'm pressing you on, are there any passages in these cases that look at that particular labelling?
No.
So it's your
Which is why
analysis, because we're starting with an equitable principle.
Yeah.
Is that?
Which is why I go back to the point that this is like an exam question at the end of the day with no authority bang on point. That is the position at the end of the day. There are cases in which the analysis is in equity. The end conclusion is the award of a monetary award. And since no one was seeking an injunction or damages in lieu, it can't have been that damages in lieu was the relevant label. You can't explain Wilkinson, you can't explain, Thamesmead, you can't explain Elwood on that basis. What is happening is that equity is intervening to provide a remedy that is in substance akin to the damages that you would get if you were the original counterparty to the contract.
You say equity is intervening. I mean, that's begging the question.
Well, it isn't begging the question with respect, my Lord, because the obligation to arbitrate here has been established to arise at equity. That's what the earlier litigation has established. All the forum cases establish that that obligation that arises at equity is treated as if it were a contractual obligation. That's why angelic grace principles are extended.
Well, when you get to J. Bowler, perhaps we can look closely at whether there's actually an obligation or whether it's just the intervention of equity to prevent somebody from unconscionably asserting a contract.
Yes, well, I'm going to come to that passage in J. Bowler on which so much attention has been focused. Absolutely. Momentarily. The point I was making, however, is that this analysis, that it doesn't give rise to a conventional cause of action, which is also a central animating feature of the two Lady Justices' joint judgment at 252 to 254, page 215 of the bundle, the idea that the obligation only works in a defensive manner rather than enabling a claim to be brought that requires positive action, such as the payment of money, that's obviously wrong. You can't reconcile what is said there with the mining or estates cases, and with respect, the attempt to distinguish Thamesmead, at paragraph 256, page 215, Thamesmead and Halsall, and for that matter the other cases, it doesn't make, with respect, any sense, because the last sentence says those cases concerned actions not for the consequences of a breach of duty, but for the enforcement of a condition or incident of the contract that the landowner was taken to accept on a continuing basis by using the relevant services. Well, that's a distinction without a difference. That's the entire essence of the positive obligation that is being enforced, and enforced in such a way as to generate a cause of action for arrears of maintenance that are due. Yeah. So if there is a breach of obligation that has led to loss, why is that not a cause of action? It plainly is. So what you...
Just to be absolutely clear, why do you say that these cases are not Lord Cairns Act damages?
They can't be, because no injunction or Section 50 relief is sought, and at least two of them.
And do you need to seek?
You do, according to Lord Reid in Morris Garner. You do. You need to seek an injunction and Section 50. That is another debate that there has been about the nature of Section 50 damages, whether or not you specifically need to invoke the injunctive jurisdiction of the court at the time the claim.
I mean, if it was the case that they could have had an injunction, but they didn't actually seek one, I think there is authority that would indicate that you can go for equitable damage.
That was the view that effectively was disapproved of by Lord Reid in Morris Garner. Okay. And he said he thought, I can't remember the exact words, but the better view was that you needed to make the claim for the Section 50 damages.
Right. But the reason I'm pressing it is that, of course, we know in our case you cannot get an injunction.
Yes.
And I'm just positing to you whether there is a possibility that these cases could be ones where an injunction could have been sought.
Well, it's not hard to posit a case where no injunction could be sought in a case like this. Let's say the relevant right of access has come to an end, and all you're seeking is historical arrears. The logical consequence of the Section 50 argument is that the relief in question is purely prospective, and there's no cure to past breach. That's one of the things that we suggest makes it extremely unlikely that it's a solution. And bear in mind, Section 50 is a very, very unusual remedy. It is a remedy that provides single, one-off monetisation of future claims for future breach, so as to create a res judicata as to your ability to complain of breach in the future. That's what Lord Justice Millis says in Jagged and Sawyer. A party has a remedial choice as to whether or not to invoke Section 50. There will be many circumstances in which I don't want such one-off for the future monetisation, because I might think it produces a number that doesn't accurately reflect the risk I'm undertaking, and I choose instead to wait for future breach to happen and to sue on each occasion that it does happen. Or I seek an injunction. If I get an injunction and the injunction is breached, I sue for damages for breach of the underlying obligation the injunction was enforcing. The Section 50 damages is always a remedial choice. Always. And it's one
that is a matter we're going to have to think about in this case, is it not?
It is.
About, even if it is equitable compensation, what you can actually get at this moment in time. I just flagged that as just a concern running through my mind.
Yes, I understand the point, my lord. So, if we're right that these are claims for causes of action, then the only distinction you have is the very technical one, that there's some magic difference between suing for a pecuniary obligation and suing for a non-pecuniary obligation. That's falsified by West Houghton, point one. And point two, it's a distinction that's impossible to defend on the plane of principle. What real difference could it be for the purposes of justifying an equitable response as to whether or not it's an obligation to compensate, or an obligation not to do X, and when someone does X, you ask for compensation? There is nothing but formalism between the two, and it's precisely that type of distinction made at law that it's the role of equity to undo. So we say, when you understand the nature of the relevant principle, when you understand the demands of consistency, emphasised by J. Bowler, when you understand the demands of equivalence, identified by Lord Justice Mayles in Airbus, in a passage we say that could have been lifted from AIB or from MOFU, because it's basically saying the obligation is in substance contract, it's coherent therefore to apply contractual relief.
Where did Lord Justice Mayles get that from?
The idea of equivalence.
Of an equivalent obligation?
From the very nature of the benefit, as I recall, from the fact that the obligation, once imposed, was in substance contractual.
He didn't get it from any previous authority.
I don't believe, I'll check that over lunch, but I don't recall that he did, no.
I mean, that's where...
First principle analysis, I think.
That's where, well, it was in his concluding paragraph.
Yes.
I mean, that's the first place that we see this concept of an equivalent, equitable obligation.
It's the first place that it's articulated in the forum cases, but I'd suggest that the same notion, frankly, informs all of the mining cases and all of the estates cases, because it's...
As you pointed out to us, all of the mining cases and the previous cases were cases decided at law without any reference to equity. You choose to attach the label of equity to it.
The estates cases were decided in equity. That's the whole point. The whole point is there is no obligation at law, no privity of contract, but equity nevertheless responds.
They didn't. The cases did not state that that's what they were doing.
No, I've been candid about that. They don't say
Yep.
it's equitable compensation in equity.
So the characterisation of the obligation as an equitable obligation first sees light of day in Lord Justice Mayles'.
Yes, and I would suggest that's the proper way to rationalise the earlier cases.
Well, the alternative way is to take them at face value and to say that you can have a legal obligation sometimes imposed on a non-party who's chosen to take the benefit.
Well, wind the clock back to 1875 and Apston, and that's the solution that would have probably...
Well, it may not be winding it back that far. I'm not... When Mr Justice McGarry and Tito and Waddell, I think he first coined the conditional benefit principle. I may be wrong. I don't think he characterised it as an equitable obligation. He treated it as a principle in law and in equity, I think.
I think that's right, my lord. And he juxtaposed it to what he called a pure benefit and burden analysis.
Yes.
It wasn't conditioned by choice.
Yes.
And of course, that's also an analysis that fits with much that's going on. So, for instance, the fact that the party is treated as a party to the arbitration clause under Section 82 also fits with that analysis. I mean, these are, I would suggest, very fine distinctions between law and equity, which is one of the very things that we pray in aid to say why a principle of equivalence should apply. Because once you're treating the obligation as contractual for the purposes of the service out regime, once you're saying that the choice of law in the contract then determines what is the substance of the dispute for the purposes of Section 46 of the Arbitration Act, you are coming very close to saying this is in fact an analysis in law. That's you know, we're not shirking.
You say, well,
that's a point in our favour.
That's great for us. We'll have common law damages instead. That's the implication.
That is the implication. We don't much care about the label at the end of the day, my lord. We're interested in the remedy. Yes. Yes. Yeah. Yeah. I haven't got time for it. So, what then is the answer to this? The answer is, I suggested its highest, the J. Bowler. And here I can answer my Lord Snowden's questions based upon that. The case, of course, was a case arising from subrogation. We in the Court of Appeal, if not the states, are agreed that the principles arising from subrogation, assignment and direction actions are all the same, as the Master of the Rolls held at 173, page 196. The question in the J. Bowler was whether the insurers pursuing the claims as assignees were bound by the arbitration clause in the Voyage Charter. Answer, yes. And whether they could be restrained by an anti-suit injunction. Again held yes, but only on the basis of the satisfaction of the aerospatial approach to anti-suit injunctions on grounds of vexation. So what was being looked for was unconscionability for the purposes of the Privy Council's test in that case. If one picks up at page 285 of the report, 2271,
Sorry, page
2271, my lord.
227.
2271.
One, thank you.
What you get, first of all, is citation of the Padre Island and other cases we cited in our written case, and a conclusion at over the page at 286, the left-hand column, the conclusion being the insurance company is not entitled to assert its claim inconsistently with the terms of the contract. And that's the passage Lord Hodge refers to in Atlantic Confidence. Lord Justice Hobhouse then goes on to hold the insurers can be restrained by an anti-suit injunction. Now,
I mean, at that point, he says the insurance company is not entitled to enforce the right without also recognising the obligation to arbitrate. Yes. So certainly some of his language is exactly in accord with the way you're presenting it.
He means the contract. He means the contractual obligation there.
Yeah.
Yes.
Yes.
So we haven't yet had equity come into the the game.
Equity comes into the game because the analysis from the injunction is all from the perspective of the unconscionability of seeking to take the benefit without recognising that obligation.
Which could sound simply in an injunction.
Indeed.
Without erecting an equitable obligation at all.
My Lord has the essence of our submission, because the argument before the court from Miss Bucknell was on the facts of that case, and the case was queer to met. There was no damage as yet suffered. It was an entirely queer to met case where, upon the Brazilian proceedings being started, an action was started to restrain those proceedings in England. So it's not a case where damage has been suffered. It's not a case where the breach has been persisted in to the point of judgment. What Miss Bucknell was saying, see page 2272, page 286, is there is no cause of action. And true enough, there was no cause of action in that case because no damage has at that point been suffered. And it was also true the insurance company was under no actionable liability to the time charterers. Lord Hobhouse's response to that is effectively that equity doesn't need damage to have been suffered in order to respond. Equity exists to restrain unconscionable conduct. It doesn't depend...
So you get an equitable remedy.
Absolutely. And in certain circumstances, equity will provide a remedy in an anti-suit context simply based upon the unconscionable conduct in question, which may be constituted by, for instance, multiple proceedings, vexation, the facts of Grovitt and Turner in the Court of Appeal before it went to the CJUs, are locus classicus of that. All that Lord Justice Hobhouse is saying is that equity doesn't need a cause of action to respond to unconscionability. And then he goes on to point out that pre-judicature fusion, you obviously had to go to 2 courts to get your relief. Post-fusion, you can go to 1 court. But in relation to foreign proceedings, your only option for restraining unconscionability in that circumstance, a case of queer to met, is by going off for an injunction. And that's the only context in which the words your only remedy is an injunction is used. It certainly doesn't support, or it can't be taken to be intended to support, the idea that in all circumstances all you'll ever get is an injunction. It's simply responding to the facts of the case in a queer to met context. And that's why we say Lord Justice Males was quite right in Airbus at paragraph 92, page 1035, to point out the queer to met nature of the case and to say the question of other remedies did not arise, because it didn't. Now, of course, what happens after this case is that later cases then go on to say, in fact, it's not the error spatial test that applies. In fact, it's the angelic grace contractual principle that applies, because once a conditional benefit analysis applies, the successor to the forum obligation is in precisely the same position as the original party, at which case the strong presumption of the grant of an anti-suit injunction arises as a matter of the contractual obligation. So effectively, the subsequent case law, Yusuf Sepsioglu, synthesises the conditional benefit case with the pure contract case. So properly understood, there's nothing here that begins to support a defence-only thesis. And what's more, if you look at the reasoning of the Vice-Chancellor, Sir Richard Scott, his analysis at page 2277 has a much simpler approach. He basically cites Halsall and Brazel and Tito and Waddell, showing how the reasoning of the court is rooted in the conditional benefit principle, and then he goes on to say that once the conditional principle has applied, i.e. once you've got your equitable trigger, DAV's entitlement to enforce the arbitration clause is thereafter a contractual entitlement, and WAV's attempts to litigate outside the arbitration is a breach of DVA's contractual entitlement, such that an injunction is, and I quote, the prima facie remedy. Not the only remedy, the prima facie remedy.
Sorry, where exactly are you citing from?
That's 2277.
Yeah, I know where.
It's the bottom of the first column, I think, and the top of the second column.
I'm grateful, my lord.
So this is one of the passages I was looking at when wondering why it isn't simply a contractual analysis and why equity needs to come into the picture here at all.
I think you've got my underlying answer to that, which is it's a fine toss-up between law and equity. But the one thing as to which there's no difference is that there is an obligation, and the obligation should be fully enforceable on the plane of all remedies, and should result in either damages or a remedy, equitable compensation, that's effectively the same. So we don't think Yusuf Setnioglu and Mr. Lord Justice Longmore's citation of this passage really advances matters. What does advance matters is that paragraph 24, page 2290, where Lord Justice Longmore cites, and this goes back to a point my Lord Snowden put to me, he cites Halsall and Brazel and says that the effect of the J. Bowler is that the commercial court became free to follow the path pioneered by the Chancery Division 40 years earlier.
Sorry, you'll have to give me that reference again because I was still looking at the previous one.
2290, paragraph 24.
Who's this?
Or Justice Longmore in Yusuf Setnioglu.
So just going back to the J. Bowler.
Yes, my lord.
You're saying that the comments made about cause of action don't tell you very much.
No.
Because in one sense, there is a cause of action. It's the breach of an obligation, breach of an equitable obligation or an equitable wrong, as I understand your submission.
I'd say there is a cause of action once damage has been suffered.
Once damage has been suffered.
That completes the cause of action. Before that, equity is intervening quia timet. Whether you characterise purely quia timet.
We don't need damage for a breach of contract cause of action, so why are you stressing damage?
I'm stressing it to identify the point of difference between the facts of that case, where no damage had been suffered, and as such, parties not coming to court to seek anything other than an injunction. No other relief was sought.
You can't turn on damage.
Well, whether or not there's an obligation doesn't turn on damage. What your remedy may be turns on damage, or the prospect for damage.
Yeah, just concentrating on the cause of action. So
yes.
I may have misunderstood what you were saying. What's your precise... I understand entirely the second point you're making about what was said about an injunction. Yes. Has to be seen in the context of that case, and it can't be read across to say there's no other conceivable remedy. But I'm just at the moment pinning your first argument about cause of action. So what are you saying about cause?
Once there's a consensual choice, yeah, and once there's action inconsistent with the consensual choice, i.e. breach of the obligation, at that point there is a cause of action in the sense that you can invoke it before the courts to access relief, like an anti-suit injunction on angelic grace principle.
So in what sense are you So are you just saying they were wrong to say there's no cause of action?
I'm simply using it to contrast with what Ms. Bucknell was arguing in that case, because she was saying this isn't a cause of action at law. You don't have any damage. You haven't suffered any damage. You're not coming to court with a breach of contract. and therefore there's no sufficient...
What I'm getting at is you don't come to court with damage for a breach of contract claim anyway.
Well, you either come
per
with...
se.
You come with damage or a threat.
It's nothing to do with the cause of action.
Well,
Well, in an angelic grace type case, you've got a contractual right not to be sued, and when there's a threatened breach of that right, you can get an injunction in advance to prevent that breach.
Yes.
And you're saying, I think, that analysis could actually have been applied in the J. Bowler. The law subsequently has gone there.
Yes.
But at that stage, it was being looked at not on the basis of a threatened breach, but on the basis of unconscionability, an alternative basis for seeking an injunction.
Absolutely right, which is why, after the passage in question, Lord Justice Hobhouse goes on to cite the aerospatiale test as a relevant test, and it's unconscionability. And he says the conduct in question, trying to take the benefit without the burden, is unconscionable. But what the subsequent cases make absolutely plain is that there is an obligation, and as my Lord Legate has already pointed out, the language of obligation is also present at other junctures in Lord Justice Hobhouse's speech. It's the language of obligation and breach of the obligation. It's certainly a deeply infirm basis on which to erect an objection in principle to equitable compensation ever being a remedy. And yet it is the only authority, ultimately, for which that defence-only proposition is cited. And then the last authority the states point to as somehow inconsistent with there being some positive obligation enforceable as a cause of action, we would say, is Atlantic Confidence. But you have my submission in relation to that.
Before you go there, we didn't quite get into the Koglu.
You set me Oglu, he says, his best Turkish pronunciation.
Well, there were two judgments in that case. One was Lord Justice Longmore, but the other was Lord Justice Moorbeek, who I think approached it on a slightly different basis.
Well, his speech, as I recall, was principally directed to showing why effectively the streams have merged and why angelic grace principles should apply.
Well, could we just have a look at it? It's 2279, I think, isn't it?
That's
2279 is.
Yep.
2297 is Moorbeek, is it? But
so which bit of the decision of Lord Justice Longmore did you want to?
No, it's later.
It was paragraph 24 of Lord Justice Longmore, page 2290, was the passage I referred to earlier, where he cites Halsall and Brazell and says the effect of the J. Bowler is the commercial court became free to follow the path pioneered by the Chancery Division. And we say the path pioneered by the Chancery Division and Halsall Brazell is a path in which, if you breach the obligation and cause damage...
Sorry, where does Lord Justice Longmore talk about the commercial court being free to follow the path of the Chancery?
Final sentence, paragraph 24.
Final sentence of
Paragraph 24.
Thank you.
The effect of the J. Bowler, it's letter H. What this shows is that it's the same conditional benefit reasoning in all of the cases. It's the same well of principle. There is no separate well of principle for forum cases. Which means that you have to reconcile whatever you say about defensive only with the obvious use of conditional benefit reasoning for an aggressive or offensive purpose, which is to recover payment of arrears. And as I recall, the speech of Lord Justice, or the judgment of Lord Justice Moorbeek, is principally concerned with explaining why, effectively, angelic grace approach should now apply in a conditional benefit forum case, such that it's an easier test to satisfy than the aerospatiale test. That's the principal exercise he engages in, reconciling through transport, etc., and choosing, in the end of the day, to follow the through transport approach.
Is it paragraph 45 to 47, Lord Justice Moorbeck?
Yes.
And
yes, and in particular, if you look at the top of 715, the question is, as in the Harry Boom #1 and the Prestige, is not how the claimant obtained a right to recover against the clients, but what the right he obtained. And he says the right, his analysis is that the right is in effect contractual. C46 and following. It's now well established that a person who becomes entitled to enforce a contractual obligation can do so only in accordance with its terms. It's all conditional benefit reasoning. So I was... I
mean, is this analysis anything more than effectively saying what this is an exception to the rule of privity of contract, or is it not?
I think with respect, that's what all the conditional benefit cases are really about, because the argument always runs in the following form. You saw this back in Aston, you see it in the estates cases. The analysis goes, but there is no contract. Well, you've taken a benefit under the contract, and for that reason, we're going to make an exception to the rule of privity of contract. Ronan Stevens uses the language of exception to privity, I recall. So we don't think that the analysis in Atlantic Confidence really takes matters any further, despite the state submissions, not least because the case has absolutely nothing to do with remedy at all. What it's only to do with, ultimately, is whether or not the conduct in question was sufficient to trigger the principle. And the real point on which that case turned was that the mere provision by the equitable assignee, the bank, of a letter of authority to receive payment couldn't be conduct that amounted to the taking of the benefit. And since it didn't, the entire conditional benefit analysis failed and the relevant forum clause didn't apply. That's all that the case is authority for. So we say, therefore, stepping back, J. Bowler, etc., are to be understood as cases on their facts dealing with the particular issues before them, rather than an enunciation of any kind of wider general principle of defence only. Any such wider principle would be impossible to reconcile with the conditional benefit case law from which J. Bowler, etc., seek to draw, because it's inconsistent with the mining and estates cases and with Halsall and indeed Ronan Stevens. Instead, we say the requirements of consistency, equivalent and fairness, the key features of the nature of the benefit in question, dictate on AIB grounds that relief in the form of equitable compensation should be granted. Let me then address very quickly the arguments in relation to Lord Cairns Act, because the argument of the Court of Appeal is effectively one that supplements its conclusions on defence only by reference to Lord Cairns Act and the notion that somehow making equitable compensation available here would circumvent or cut across Section 50 of the SCA. And that was an argument that had been made to Sir Peter Gross, not to Dame Elizabeth Gloucester, and it was made to Mr. Justice Butcher and rightly rejected by both of them. There's a couple of points to note at the outset. First of all, I'd suggest it's unclear when you read both the Master of the Rolls' judgment and the second judgment what the precise effects of Lord Cairns Act, or now Section 50, is said to be. There are two candidates, I'd suggest: a regime of ouster, i.e. you get no remedy in equity other than that provided by Section 50, a bit like the ouster of common law restitution by statutory rights of restitution in a tax context. Or it's a regime of ossification. You only get equitable compensation or monetary relief in a case where equitable compensation or monetary relief, whatever the label would have applied, would have been awarded pre-Lord Cairns Act. That's the first point to note. The second point to note is that precisely this argument has arisen in the context of breach of confidence, which is why there is treatment of it in the textbook referred you to earlier, and why it's addressed in Force India. And I said I'd come back to Force India, and I shall. It's at tab 65, page 1627. And in that case, Mr. Justice Arnold addressed the first question of whether or not Section 50 ever even applied to an obligation that was one of pure equity alone. And secondly, whether or not equitable compensation was available. And he reached the conclusion, page 1650, supported by some academic commentary, that Lord Cairns' Act didn't even apply to an analysis that was in pure equity, not least because it was about stopping parties being bandied about between law and equity. So he said Section 50 damages weren't available under Section 50. The exact converse of a conclusion of ouster, he's concluding it's just not available as a remedy in these circumstances. But it goes on to conclude at first principle that equitable compensation is available. Now, the ouster argument...
Where is that, sorry?
The analysis on why equitable compensation is available is at 392. My note tells me page 165. 1651.
50.
Sorry, 165...
1651, I believe, my lord.
1650, that's where he's looking at the argument.
At the bottom of the
1651.
page it starts, does it?
What?
Yes, 1651.
1651.
It's paragraph 393, where he reaches the conclusion that the Lord Cairns' Act does not apply. In other words, there's no question of ouster, it's simply not applicable. But the remedy of equitable compensation is available. Either way, however, it seems clear that monetary relief can be awarded to a claimant who suffered financial loss. So he reaches that conclusion by a very different route.
Okay. But that is the authority for
That's the
equitable
English
compensation
authority. Yes.
for breach of
Which is
confidence. I'm inclined to the view that.
Yeah.
Okay.
Supreme.
And does he then go on award?
I'm so sorry, my lord.
Does he go on then to award compensation in the actual decision?
Can I check over lunch, my lord? I'll come back to you on that.
Overnight, did you say?
Over lunch.
Over lunch, sorry.
There have been lots of cases, haven't there, where equitable compensation has been awarded for breach of confidence.
I think there's a fair number of authorities where the point has effectively been assumed, and that's often because the equitable duty overlaps with contractual duties in any event. But all of that is analysed in Toulson and Phipps. The authority I was going to refer to, because it most directly grapples with the ouster point, is the Canadian case of Cadbury's and FBI Food. That's tab 1142929 of the electronic bundle. And many of the same arguments that are effectively made by the states were made to the Canadian Supreme Court in that case. And the Canadian Supreme Court concluded in terms, firstly, that Lord Cairns' Act was not an exhaustive remedial code.
Sorry, firstly that.
Lord Cairns' Act was not an exhaustive remedial code. In other words, it didn't oust any potential to award equitable compensation.
Well, it was meant to be improving your position, not worsening it, Lord Cairns' Act.
Absolutely. You anticipate my next point, my lord. But anyway, the second point the Canadian court decided was that applying, by analogy, principles from Nocton and the development of equity was a principled development of equity to award equitable compensation for a purely equitable obligation to arbitrate. And that's the conclusion that the authors of Toulson, page 3094, themselves reach. Drawing attention to the concern created for that conclusion by the ouster reasoning of the Court of Appeal. And they're right to do so, because if the Court of Appeal is right in relation to ouster, it's ouster of equitable remedies of equitable compensation wherever they arise, whether it's conditional benefit, whether it's proprietary estoppel, whether it's breach of confidence. The language of the Act is not language that supports any equity-based distinction of that kind. And that leads to the two fundamental problems with this argument. Fundamental problem one is its logical width and ambition and the remedial lacunae it will inevitably create. Its logical width and ambition is the whole of equity is affected by this analysis, and the lacunae is you will never get monetary relief in any case where an injunction is not available at the time the claim is issued. And there may be many cases where that's possible, possibly the cases. Immunities is one bracket. Another bracket is when the equitable obligation has ended, or the parties died, or impossibility intervenes to prevent an injunction ever being available. That would leave equity completely incapable of addressing past breach. So that's
Have you got any pinned reference for Cadbury and Schweppes?
It's 2929, the particular passage, my lord. Sorry. I had it in my notes. It's at managed to omit it. Here it is. It's at 2964, my lord.
2964.
Starting G, the relevance of Lord Cairns Act 1858, the jurisdiction to award financial compensation. And it runs through to the end of that section, which ends at page 2967. Thank you. So the first problem with this argument is one of its breadth for ambition and the remedial lacunae it creates. And the second problem, and it is a fundamental one, is that nothing in the language of Section 50 or its Lord Cairns Act antecedents supports it. The test for remedial exclusion is the test is called identified in the Wolverhampton, in the Manchester Ship Canal case, paragraph 123, page 2747. It's a strict test. If you're going to take away private law rights, you need clear statutory language. And nothing in the language of this provision suggests the remedy is anything other than purely additive. Its role is to provide additional remedies, not exhaustive remedies. Its role is to stop you being bandied around between law and equity and enable you to access a remedial one-stop shop. And if that's its function and that's its language, it doesn't support the weight of the argument that's put upon it. Is that a convenient moment?
I think it's a convenient moment, Mr. Delamere. You have until 2:40.
2:40. I will review the remainder of my notes, probably no more than 5 minutes on the rest of what I have to say before handing over to my learned juniors. And if I go beyond 2:40, I understand it will come off my time and reply.
Very well. Thank you very much. 2 o'clock then, please.